Hello there, fellow English Law Series listeners and watchers and viewers and studiers and all those sorts of things. Yes, it has been some time since I've put my face to camera and decided to bring out another video. It's been kind of a state of hiatus. A lot of things came to sort of a crescendo of all the different activities I had myself involved in. And they were involved in bills of exchange, with other cases, with my own case, interactions with police officers, and dealing with questions and so forth that people have, dealing with a court of appeal in the other end of Canada, on the other side, and putting that together, or more or less being more of a watcher to the put together, or the necessary ingredients to put an appeal together for the questions that we were not satisfied in the Supreme Court. And so just lots of things. And if this is your first time ever clicking on one of my videos, this is for you as well, because this is going to be, to me anyways, an important video. If you are caught into a court case yourself, are maybe pulled over, or get involved in some sort of policy enforcement interaction, and you want to have some sort of confidence in dealing with that matter. But more importantly, if you are caught up in a court action whereby it's not your fault, I mean, you haven't intentionally injured somebody or done something like rob a bank or something to that nature, but it's not your own your own action, but the actions of territorial jurisdictions and so forth. Now, maybe what I'll do to begin this is I'll give you first a police action. I'm not going to talk about a lot of other things, even though they're going to be sort of intermixed with some of the things I'm going to say here. But I'm going to deal with the court, and there's a reason why, because the potentiality of a court or a judge deciding the case immediately in his own mind as you begin to speak, present yourself, through the device of what they classify as a organized, pseudo-legal, commercial arguments. And to give some base to that, the Freeman Sovereign movement, from what I have gathered, started essentially from the 1950s. People started to question taxation, their obligations under government. We've reached a higher pitch, definitely in the last 20 years. Everyone exchanging information in order to find out how to deal effectively with having full inherent rights in every circumstance that you're on, and not to be overshadowed by presumed or assumed agreements by government or other parties. And this has resulted in the courts now getting a lot of this kind of interaction with people that are expressing their rights and trying to discern where their freedoms begin and where they end, and how they're caught up and affixed to agreements that they don't even know that they have. And we've all been part of that, especially, again, if you've caught to this video, then maybe the subject line has caught your attention, or has brought you to this matter, to this video, and trying to figure out maybe what can I do immediately in relationship to a court issue, or a potential court issue, or a potential stop by police officers for things like not having a license, maybe driving while under prohibition to drive through some sort of act or statute within your own country. Maybe dealing with council tax or whatever, things that are imposed upon you that you think you have a right not to be, brought into the matters of a judge, where he's going to make a independent decision on how he wants to act with you. And again, in most all cases, any judge today would be filtering through the mind of an OPCA. As soon as you start to talk freeman or sovereign language, but even now it's come to my attention, which is a lot more for those who have been following me and the English law series, is when you are bringing in the law. And maybe I'll begin by saying, before I begin with the history of how I arrived here, is I was wrong, inasmuch as those people that had stated you should never find yourself in court, I said, well, how else are you going to get a matter solved and moved into the public? And it was my thinking, and through a lot of interactions, that it's only through court that you're going to have the opportunity to, deal or to have the right to now enter into the private. Now, there is some truth to that, but I'm thinking we can bypass that altogether and get to the heart of the matter. It's getting a little chilly out here. I didn't think sun was out. You see blue sky, there's some of it right there, but apparently where the sun is, which is somewhere over there, well, it's a little cold. A lot of snow has melted. There's hardly anything out here now. You can see around my property there. It's been a very mild, very short winter. I think it happens like every 7 or 8 years. We have these winters where, by March, end of February and March, you're ready to go and hit the golf course. And but yeah, see the valley's got some sun and everything else, but me, no, I'm going to be subject to a little bit of cloud. Okay, now where was I? I was going to go in, but was going to speak about the history, and maybe that's what I will begin with, and that way you got some context to how I arrived to deal in court and found myself in court, and then willingly, that's what I wanted to do, and then through that interaction and a deeper perspective of my awareness of what law is, and look to the devil in the details, that I come to a conclusion. Like I said, I strongly hope that it's going to help everyone who's listening to the video. And at that moment, I'm just going to go in and we'll start anew here. All right, now that I'm inside, let's begin. Okay, let's go with the history, bit of a segue to me arriving in court, and it was through a traffic stop. Now, the fact of the matter is that I knew I was going to be stopped. It was like a 2-hour sort of an operation waiting for me to get into the vehicle so that they could stop me. Now a little bit extra pretext to that was that for years, for at least a minimum of 2 years, in a small community, not more than about 4,000, I have been driving around in a vehicle, unabated, and of course, they know that I don't have a license. What was the reason all of a sudden I was stopped? Well, I can only assume, don't have the, of course, this information, is that I had a Supreme Court case that was open against that brought in the Attorney General of the province. And if I was ever stopped, well, what would have always occurred is I would just went right to and filed that, hey, well, I've got the Supreme Court case open. It's a jurisdictional issue. And so therefore, I cannot engage in any other issue because the preemption of that I've already engaged in this. So, it's a matter of time, first in time, I guess we can say that this has to be settled first before I could even, begin to speak to lower court jurisdictions. And I think that was a get out of jail card, and that's why no one touched me. I then subsequently dissolved that petition only because it reached its end. We weren't getting anywhere, and I didn't think that the means in which I wanted to arrive were going to be met, and the Attorney General and the Legal Services Department and the Deputy Minister's office all got involved, and it was just an opinion piece that they weren't using anything, and it was just all based on opinion, and it was I just garnered enough information that I thought was necessary, and it was just done. I'll start a petition a different way when I come with better information in how to affect my rights within a court or a formal court. Now, moving forward, pulled over, a few cop cars right away. They knew who of course, said they were waiting for me. And of course, the question is, can I see your driver's license and registration? Well, that was a rhetoric question. They already knew the answer. To which I then said, I give him my card. And if you're not familiar with my card, it's just a business card. On the front, it says, I do not answer questions. It then relays the fact that Her Majesty acts as Fidei Commissioner. At that time, of course, when I made the card, Queen Elizabeth was still alive. And on the back is the subsequent supportive laws that then I will not overreach. I have a right to that when it comes to matters of the jurisdiction that I'm supposedly within or within the territorial right, they can't overreach that right based on the notes of that card. But I also know, and I'm going to give a caveat here, that when I use that card, I know I'm dealing with policy enforcers, which means they have no liability to uphold the legal, the same measure of legal obligation than, of course, what a lawyer or a judge would have. They are just enforcing a policy and whatever they're told to enforce. They don't. When you give them a card, it doesn't mean anything to them. But what you're doing is providing evidence that you've done your best that you could at that point in order to get the message across. But you're dealing with a party that you can't speak to. So they've got something and you gave them something. So there's that communication and that agreement. Whether that other party knows what the agreement is irrelevant. But they pulled you over, you gave them that card, and now that agreement still can be then constituted based on the fact of delivery. Now, the exchange went back and forth. When they went right away, they said, who are you? What's your name? They already knew. They're playing the game. Of course, I told them why I don't have any problems telling my name because, again, it's based on capacity and status, and I know what my capacity and status is. The capacity, in case you don't know, is through the life tenant, and status is in the system right now as a beneficiary. So another cop I give him the card. He just throws it on the ground. Sure, there was litter laws for that too, But anyways, he threw it on the ground. Okay, whatever. And what's your date of birth? And then they just start peppering, kind of a lot of things. What's your date of birth? And I said, yeah, it was a question. I said, is that a question? He goes, yeah. I said, okay, I'm going to answer that one. And I gave him my date of birth. When any other questions were quickly answered, and it happened really quite quickly because they knew exactly where they wanted to go to. They knew they wanted to escalate the situation. That's what they were all pumped for it. So, hey, they've got to get their desire. They got to meet their desired goal of how they, as they began this this interaction. And again, all pre-planned. And they asked me to get out of the car, and I said, well, am I obligated? Yes, you are. Again, don't fight with them. It's again, you're dealing with policy. So I got out, rough at the very beginning, asking you, or pushing you around, trying to make you do things that you're not aware of what they want you to do, but then at the same time, by not doing them, it could maybe escalate into you're not, resisting arrest, and you're doing a myriad of other things they could come up with. And, it's being a little rough and everything else, and whatever. And then, of course, the reading of the rights, to which and now here's the second part. In the reading of the rights, they then confess that you have the right to remain silent. So the first is a card, I do not answer questions. And the second now, I have the right to remain silent. So just those 2 points already validates that you do not need to converse with them at all or do anything they tell you to do unless they do it by, and you're going to find out a reason why I'm going to say this, unless they direct you, like physically hold you and carry you to the position where they want you to be. Do not do it on your own accord. Let them be the ones to move you around. And again, we'll get to the point. And then now it's a series of questions, to which, guess what? It's an ease. It's easy breezy. Every question is going to be answered in this manner, to which I did in every circumstance where they ask anything. And then if there's a question in it, I would say, is that a question? And they would say, yes. Like, for instance, when they read something, they'll say, do you understand? Like reading your rights. Do you understand? I would say, is that a question? Yes, it's a question. What does my card say? Okay. That's it. I'm serious. Everything they said. And even when they try to engage in conversation, you're part of the free man sovereign movement? Is that a question? Yes. What does the card say? In as much as, and when they direct me into the vehicle and put me into, in their vehicle in the back so they can go into the other vehicles. They had like 4 vehicles, and they had another person witnessing the whole thing. So training or whatever they were doing. And they were kibitzing and speaking of what to do, and they would come in and make some obscure or absurd reasoning to try to engage in conversation by making something that is not at all with solid validation. For instance, you got some rust on your door. That may impair the integrity of your vehicle, in as much as we're going to have to send it into inspection, get it inspected before you can drive it again, or before anyone can drive this vehicle. Do you understand? Now, come on. Some rust on a doorway now needs a full inspection of a vehicle. Yeah, we know better. And there was a couple other things that were just so absurd. I didn't get engaged. Of course, when a question was asked, what did I say? Is that a question? Yep, you qualify it. And what does my card say? They bring me out, and there's a bunch of citations, tickets, whatever, on top of strewn across the top of their vehicle. And they were writing one instrument, and it was a first appearance notice. And they put me about 5 to 7 steps away from where they needed those, where they were writing those documents. The officer, of course, starts talking about this first appearance, and he goes through it. And, you may be arrested if you don't appear. Else, do you understand? Okay, you already know what the response is. And he says, well, you need to come over here and sign it. Now, getting back to, or sort of connecting to what I first spoke about, don't move, let them direct you. And here's the reason why. I'm in handcuffed. They put me purposely 5 to 7 steps away. Okay? There's a cop in front of me, a cop beside me. The one that's beside me is the original arresting officer, and he's the one who wrote all the tickets, and now he wants to speak to the notice of first appearance. And he's asking me to walk over there. Now, if you walk over there and you just, accidentally trip, okay, walk a little too fast, maybe show that you're coming, maybe you're angry a little bit, don't be, okay? Don't be angry. Just let them, they're policy enforcers. They have a job to do, let them do it. But if you come in like, he threatened me. His look was so threatening, so I brought up my taser essentially to give him a zap because I was afraid. Or if I tripped and I bumped into him, then there's a potentiality for them to throw me on the ground and saying, assault of an officer, those kinds of things. You don't give them the opportunity. Be vigilant and cognizant of the potentiality for this to escalate, or if they want it to escalate, and if they can't get it to escalate, they're going to try. So I didn't move. Well, you need to come over here and sign this, is continued. And when I didn't move, he went into, well, listen, I was a little rough at the beginning. I'm sorry, that was a little aggressive for me and stuff like that. But listen, we can all go home. There it is. Same thing that judges do. It's just running over to, okay, this is not working. Let's try the nicer approach, the friendly approach. Okay, we can all go home. You can be on your way. We can be on our way, and you don't have to worry about this until the first appearance. And of course, the answer, do you understand that you need to sign this? Okay, what's the response, people? Is that a question? Yeah. And where's my card say? I changed it up a little bit too. When they would ask a question, and I said, well, am I still under arrest? And they said, yes, you're still under arrest. And I just shut up. You're on both sides. You just, again, you shouldn't talk at all. Let them do what they need to do. And of course, then the threat comes in, well, if you don't sign it, you're going to jail. Do you understand? Yeah, exactly. That's what you say. I know you're saying it in your mind now. That didn't work. The other officer, now the aggressive one, now the new aggressive one. Why do you have to be like, with this whole thing, not respect the law? Well, I'm not going to get into that discussion because, again, I'm under arrest, and I know the reason why. They're not using law. I am, and I respect the law 100%. They don't know the law to respect it. They want me to respect policy, and they don't know that. There's no sense even engaging in a conversation. But at the same time, that's another hook to get you into some sort of agreement that they can now insert themselves in order to move further in their agenda. So he said, if you should listen to officer, constable, so-and-so, and if you don't, like he said, you're going to jail if you don't sign this paper, if you don't sign that paper. Do you understand? Yeah, you're right. That's my answer. Well, after a little bit of talking back and forth, they obviously weren't going to get anywhere. They needed my agreement. In fact, he needed my agreement to even get to the first appearance. And why, and I'll give you the reason why I went. But when it was not getting anywhere, they uncuffed me, and they asked a question, and of course, when they asked that question, they said, here, take these papers, or you want me to put the papers in the vehicle? Well, I'm not going to say anything at that point. To which then I asked, I said, well, am I still under arrest? And the officer said, in a more of a stern voice, well, no, you're not. He said, we took off the cuffs. What do you think that means? I said, okay. And I went over there and shook his hand, and I said, listen, nothing personal against you, buddy. You've got to do your work. In fact, and this is serious. I'm not trying to create some sort of, that word sophistry? No, there's something else that I'm thinking of. A word that you're sort of, bowing down. You're trying to try to, be in their favor. And you're looking to, arrive at a certain connection that wasn't there before. But the reality, I meant this, in all honesty, that I could not do your job. And I appreciate the work you do. I mean, there's so much out there that if I was doing it as I was a cop, I wouldn't even have lasted as a cop. I couldn't. Because I knew what my aggressiveness was at that time, and so many people would have pissed me off. Okay, it's a tough job, and I did that with both cops. I did the same thing, thanked them, for the work and everything else. And there's no hard feelings. It's not against them because I have the law. They don't have the law. I'm the one who has all the power. They don't have any power. They don't know that. I do, so I have to be the responsible one. I went on my merry way. Part 2, the first appearance. Do I need to go? No, I didn't. I wanted to. And I wanted to through my initial belief that the only way I was ever going to get into the private and deal with my estate is by standing before a judge and then moving that judge into the private, to which then we can speak. Because again, I went to the Supreme Court and it was just a bunch of a circle jerk. I see other circle jerks going around with other matters pertaining to the law that they're not ready to. They're ignorant or we're approaching wrong. Now, again, what I always maintain is if you want 100% responsibility, means you got to take first responsibility, and you can't be objectively pointing your finger at someone else. Every matter, no matter what it was, even the cops, is my responsibility, my fault. Because if I was totally out of the system, would I have been ever pulled over? And if I was pulled over, would I not have the certain whatever instruments may be available to me or just give them my name, and they would say, oh, sorry, or my car, whatever it may be, is my fault. I am the one, for whatever reason, have not satisfied the system that I do not belong in their jurisdiction. My fault. Get used to that. If you're getting pulled over of any circumstances, getting drunk through court, it is your fault still, because you don't yet comprehend exactly where your power is and how to separate that power from the assumption of jurisdiction within their grasp, within their hold. So first appearance wasn't really going anywhere. I already give you my intent, but I sort of allowed the court to proceed because it was just a first appearance. I needed to proceed to first to a hearing to get a plea, and I thought that's probably the better way to start discussions. And so I said, yeah, whatever. And I left. Let's give me another month to contemplate and reflect on how I'm going to approach it. And like I always do, and I think it's number one, steadfast agreement with myself that has helped me in so many ways. And I generally, and just want to pass this on, that if you continue to reconcile your interactions and experiences through beliefs then you're always going to be returned the exact, well, people like to use karma, but you're going to receive exactly the action that is subjugated, or you're going to create the exact action that is relative to that belief. You have to be willing to let go of every belief, including this whole English law series. You just have to be willing to let it go, because the truth of the matter is the truth can never leave you. It's always with you. What you've got to do is remove the impurities. As I've said in other videos, water is water is water. It's only something a little different than water, if you want to call it different, is when through impurities, and beliefs are impurities. Gold is gold is gold. How you get to gold? You remove impurities. Your higher self, your soul, self-proximity is exactly the entirety of everything. How you get to that? Removal of impurities, which are beliefs. So that is always my go-to. Always, always, always. Because A, it's 100% responsible, to which then I have to be in all matters. I don't have the option of limited liability anymore, which is essentially manufactured because it had made since January 1933 that no one could pay on the principal, so you can only exchange within interest, so therefore it's only debt upon debt. You're only always exchanging interest, so then it's just debt you're exchanging. So in order for us to be in this circumstance, the agreement is for corporations to be able to industrialize themselves and extract resources, start building without being attached to worrying about the principal, because the principal is a whole different kettle of fish. That just like if you have a mortgage, you never pay the interest, pay the principal. Well, that principal always will be there, and you're always going to be subject to the interest. Well, the entire system is just interest. Okay. Back to where I was. So the next was the matter. I let everything go, waiting for new information to come in. Again, an empty cup can always be filled. So I went in there with always a plan. My goal, my one-trick pony, my on the rails, can't move off it. Where I want to end up is in the private. That's it. I want to completely vest my estate through the status of settler. That's it. Okay, I need to get there. So I went in, created the division by an initial statement and a testimony to the court that, life tenant, I am set capacity life tenant, because you're not a settler yet, of course, it can't be seen in this matter, and your life tenant capacity, subject to status as beneficiary, seeking the judicial independence of this court to deal with this matter, that then allows that we can move to the private, something to that nature. But I wanted to create the division, and he's going like, what? What? I said, life tenant, blah, blah. And I said, there's, of course, through the imposition of the the assumption of what I am acting as has brought me before this court, that kind of thing. He just says, I just want a yes or no answer. I just want a plea. Are you guilty or not guilty? Went back into my own stance, my own standing, to which I added the fact that now I said through presumption, through all presumptions, if there's the fraud and the imposition is not known, then you have the right to the lapse of time. Well, now that I've given you the imposition that was created, now you are with that knowledge. Therefore, for you to continue on in this matter, you are support of, or you are, giving value to that imposition, which is not what I think you want to do, Your Honor. But when he says, okay, we're here for a plea. Are you guilty or not guilty? I went back into it again about the imposition. He then just took the reins, took power of attorney. Okay. He's an older guy. he's pretty close to retirement. He's he looks like just on the cusp. And left sitting on the bench has really aged him. But he just took power of attorney and says, okay, I'm going to enter a plea on behalf of the defendant of not guilty. Well, what can he do now? It's done. Okay, all right. Let's move into the next one, 30 days later, which will be, and they have to go through procedure, okay? They have to, obviously, because each matter then creates a latch for them to then, if something happens in between time, they've always can show where they stopped, where that problem may have existed, and they have to make sure that they have their legal principles intact so that whenever they're questioned, they've always have the checklist to say, yeah, did this, so it can now reach appeal, and this matter can now be heard. Okay, if necessary. So the next date was, of course, to fix a date for trial. Okay, so again, same exercise. I read more, learn more. How am I going to approach it? Make it simpler. That didn't really do well. I'll be surprised if that same judge is there, because many times if you create an issue of jurisdiction or challenge jurisdiction, they don't want you to be challenging again, because that's going to a potential for an error. And I said, a lot of these judges don't want to be in that predicament. For instance, I went through 5 judges once, and I didn't know at that time, fuck all. It was still the Freeman-Solomon kind of concept, and before they flew one in. So, I mean, these guys don't want to be caught up in this, and I get it. It's their job, it's their livelihood, and they don't want to be either made an error in law, which they may get reprimanded, or they don't want to find themselves at the wrong end of a suit. And so next time I went in, I thought, okay, I'm going to first identify the Crown as a charter organization, and only in as much as that charter organization can only deal of something of the same equality. Therefore, the name that we're dealing with, and I said the account, not necessarily the name, because I want to deal with the account. That's what we're dealing with, the driver license account that's still open, to which I don't have ownership of, because that's it's owned by the province. Its legal ownership is the province. Nor do I have possession, which is obviously I banned it over 30 years ago, so it's cheated back into the owner. Therefore, without either of those, then where's my liability? Okay, so I was moving into that, and that the name had to be, or the account had to be subject to a charter right, and that charter right means that obviously that distinguishes that entity and me representing that entity in a manner that I want to present before the court in order to move it to private. Well, we went back forth just a little bit. He went through like about 4 points process. Okay, I'm sorry. I'm now at the date, which was just last Tuesday. This is Friday, so 3 days ago, to discuss fix a date. And I came in, spoke originally about the separation, to get that out, because when I said, he goes, I don't know what you're talking about. I said, well, I need to address that situation, Your Honor, for the very fact that I've got to show the division of capacity and status for this matter, and where I exist, as I've mentioned in the previous court appearances, that I'm not ineligible for the benefit of acquiring a lawyer. So I want to make sure that you will comprehend that the representation is subject to comprehending what that entity that you are creating an action, or the Crown's creating an action against. So again, we went back and forth. We went through a 4-step process of explaining things, what's going on. And I just sort of went, yeah, whatever, yeah, go on. Again, my mind, private. That's why I'm here today. I'm getting to private. I'm not messing with this anymore. I'm getting to the private. Okay, little, that little train that could, you can, you think you can, okay, but no, I'm no, okay, I'm getting there. That's where I'm going. And after that, I said, okay, I'm not getting anywhere. I've got to change tactics. And I said, well, Your Honor, I marked the instrument using the Bills of Exchange Act. And he goes, what are you talking about? What instrument? Well, then he goes and asks the clerk. He says, where's the information? And that's what they call it, information. Which is generally the security that the Crown uses based on the laws, the sections of the laws that they can use in order that creates a security against that information. And that's what they're coming in through. And I said, I've already marked that. I marked two instruments, first and first appearance, and the one that you got in your hand right now, and under the Bill of Exchange Act. So it's already defective. And then he goes, okay, we need to stand down. So stand down, didn't really understand what that meant. I mean, I'm not learned in the legal jargons that are legal procedures and methods that the bar union uses. So I only found out later when I got out of court that stand down means that they're just doing it for temporarily, but the case is going to continue on that same day, as opposed to if you were going to measure it against adjournment, which would mean some future date. Okay, so stand down, to which then the lawyer, who's in the peanut gallery, who generally is working for the defense, he said, "Yeah, Your Honor, I'll talk to him. I'll take care of this for you. While you're doing what you need to do, and me and Mr. Higgs here, we're gonna go in the back and we're gonna have a discussion about it." And my mind's going like, "Fuck, we are." Okay. And I said, I got jurisdiction here. There's a change of jurisdiction going on here. And I said, I'm not moving. And the judge subsequently gets up and leaves. And so I turn around and there's the lawyer. He's talking to me. Yeah, okay, so let's go, and we'll talk about this. And I said, I'm not moving from here. Because my mind is getting, I'm not changing it. I'm not removing the jurisdiction that's established here. I'm thinking in that mind. Again, sort of am I absolutely right? That's how things are progresses in court. I don't know. It's so much information out there. So that is, which I don't like to deal with is not knowing for sure. I don't have anything substantial I can go to. This is exactly what's happening. Because of course I'm not privy to the court processes and what they do and how they think. And there's a sheriff standing right there at the gate as well. And he goes, he's opened the gate. And I said, well, I'm going to stay right here. And the sheriff said, the lawyer spoke up and said, they had to close the court room. And I said, what? And the sheriff says, yeah, we're locking everything up. Everyone's out. And I said, okay, remember back into the principle, we're talking to a policy enforcer. What's the sense of dealing with, hey, no, I got jurisdiction and start doing all this kind of stuff? No, you're not. So what's the sense? You've got to pick your battles, right? So I said, oh, okay, fair enough. So I went with the lawyer. Lawyer was discussing how he saw things, what I should do next, and everything else. And he did bring some things up, unbeknownst to me, of the significance of what he said until I thought about it. But he was bringing things up, and I said, well, I just need to establish my rights within this courtroom, whereby, I'm not owner of that. I don't have ownership of that account. And he goes, yeah, he knows. The lawyer knows. And I said, nor do I have possession, because it cheated back over 30 years ago. So I'm not liable. And I need to go and settle this account that's now stuck in the private that I can't do. Stuck in the public, to which I have no power over because I don't have possession or or do I have legal ownership of? So I need to move this court in this matter into the private. Well, you know, you got, okay, whatever. Sheriff came and checked on us a couple of times. We got up, went back into court, said the court's open. Him and I spoke a couple. He walked across the bar, and I said, "Well, okay, well, hold it. You're not representing me here. Don't be following me into this jurisdiction or into this area of the court." And he goes, "No, I'm just giving you the paper for what you need to understand for judicial case management." And to which the Crown that replied goes, "Oh, no, this is for fixing a date for trial." He goes, "Oh, okay, then you don't need this," and he walked out. Then the judge came back in. Now the judge was holding paper. I'm thinking, okay, here we go. What do we got? What do we got going on here? You should find that paper. So he has this paper in his hand, and he sits down and he tells the clerk. He says, "Can you give this paper to Mr. Higgs?" No, he didn't say Mr. Higgs. "Can you give paper over to the defendant?" And I took it, not going, "Oh, here we go. Now I'm accepting it." But I'm curious, so I'll take the paper. And he goes, "I implore you to read this. This is actually a personal acquaintance of mine. He's another judge in the same province. And there's a determination I want you to read through it. I'd like it if you read through it." Well, I went back in my own position. Again, where was I going? I'm reconciling through my belief this is the only way to get into the private, so I'm going to stick there. I'm going to pull out the birth certificate, and I said, "Your Honor," I said, "this is the entity that is then used by the trustees in order to intercourse in the commerce, and I need, through this device, whereby I can speak to these trustees in order to settle the account that's in the private once it's exposed, so that I'm no longer now entrapped involuntarily into the matters of the public." Okay? I mean, that sounded a lot better than I did say it, but pretty much that's what it context. He goes, "Listen, I'm just imploring you to read this before you go any further. Well, we're going to fix a date regardless, and that's what we're here for today. So just do a favor as a representative of Mr. Higgs." So then he said that. I said, "Oh, well, thanks for recognizing that." So he said that for a representative of Mr. Higgs. Did I entrap myself? No, he recognized it, so I'm okay with it. And he said, "We're here to fix a date." And I went on a little bit more. Then he went to the Crown. He says, he gave a date, and they looked and said, "Yeah, how much time?" "About 2.5 hours for trial." And went back to me and said, "Okay, we have a date fixed." And I said, "Well, can I adjourn that date?" "Nope, you can adjourn it on the day, but you can't do it now." And that's the date that's fixed. Again, you got to know when to continue. You can see there was a change of energy. You can see how things were. I saw the sincerity of the judge for me to read this. And that's what was important. It was like you might look at it as, "Oh, here he's hindering my right to get into. He's not listening to me again." But there was, I had the gut feeling to stop and look at this, because I have another 30 days or so. Left the court, kind of pleased. I stood my ground, just like I did my other times. I stood my ground, a little more confident, a little more forceful, a little more not hesitant. My words weren't, I wasn't searching for words. I just went at it. And so I felt good about that whole experience. Now, I wasn't happy, of course. I didn't get to where I reconciled that the only way to get into the private is through this interaction. And so I went into a coffee house and I began reading. Okay, you know what? Maybe I'll put my glasses on here because there's going to be some things. No, you read it from. Can I switch that? No, let's see. No, I guess I just got a phone. I don't have cell service. That's why I didn't get the phone for that. It's recording and doing videos. There's been a lot, of course, well, not a lot, but there's been people complaining that they could not hear me. So hopefully this device is going to help out considerably. It was a case that was handed to me. Of course, he says from one of his acquaintances, in relationship to being of the same stature of provincial court judge. And it's R versus Hardy. R stands for Regina versus Hardy. And its judgment is 2023. Okay, so it's most recent, of course. And as soon as I went to it, you see how sometimes you don't read, something pops out and that's it. You're fixed to that thing you read. And the very first thing I read, which was the beginning of what I discussed as my introduction into this video, was he is a disciple of organized pseudo-legal commercial arguments, OPCA theory. As I explained by him, he is a free man. He proclaims that he's created by the creative source. He claims to be a man of mankind, being other than a human being. Simply put, he says he is a man, a mankind. But some legal identity on a piece of paper that was created by man not some legal identity on a piece of paper that was created by man and owned by man. Accordingly, in his mind, he is not a person or an individual, and therefore the courts of British Columbia hold no jurisdiction over him. He rejects the name of Cameron Hardy. Instead, he identifies by various names, including a man known as Cameron Hardy and a man commonly called Cameron Hardy. For my decision, I will refer to him as Hardy. Okay, wow. Woo, all right. I am going to go up this and I'm going to mark this motherfucker up, no problem. So I just start going to, court's legitimacy. It's like every sentence I start reading, I'm going, oh, here it is. Here's a mention of servitude. Here's court's legitimacy. Op litigants are, he's got the definitions of what he construes a opca litigant to be. And I don't fall in any one of those categories. He's refusal to follow court's directions and orders was deliberate and premeditated, as evidenced by the written script he had in his possession and read to the court. He undertook and calculated an intentional course of action. Well, it's like first-degree murder versus second-degree murder. Intent. You've got to watch intent. You're going to find this out in as I further proceed with this video, the importance of this. Nevertheless, OPCA litigants believe in pseudo law. It's apparently sincere. Social scientists who have investigated their populations confirm that they are true believers in this community who are driven by a combination of conspiratorial and political beliefs, reinforced in kind of social echo chamber. Social echo chamber. Let me see, look at his qualifications. They're toxic ideas. They're focused on through the guise of pseudo gurus. Where did he come into? Where he explains that he's setting the stage of how he's come to terms of this, and he's giving, of course, the foreground to establish the reasonings of OPCA. Okay, here it is. And he's bringing out a case from OPCA theory. I repeat that what I've said in ruling reorganized pseudo-legal commercial arguments, R versus Hardy. I also had the opportunity, and he says this, and I put down as, the criteria that's necessary to become an OPCA. But that's per point I wanted to reference and say, well, I speak the law. How am I OPCA, right? That's my mind, right? That's my reconciliation through my belief. I'm not an OPCA. I also had the opportunity to reflect upon what would become known in Canada and other parts of the world too as pseudo-legal arguments. And one of the interesting things about pseudo-legal arguments, regardless of whether one is the taxer of a freeman or of the land or sovereign citizen ideology, philosophy, is that there has not been a single case in Canada supporting this particular theory. Judges are, by precedent, allowed to look at previous decisions of the court, and decisions of Superior Court are binding on me. And that was one of the things that's going through my mind, is what gives them the right to now encroach on me by pigeonholing me into a category that already puts me into a lesser right. And it's not law, and of course courts can't create law from the bench, or judges can't create law from the bench. And it's not statute legislation or legislative legislation anywhere. So where is this force? Okay, what's going on here? Okay, they are, they waste the taxpayers' money, all that kind of stuff. They're misidentified with mental health issues because that's not the real reason. So now they get to go into that category and sort of less. They're talking about like being able to circumvent circumvent the court's authority by they're mentally retarded. They don't know what they're talking about. And he's saying, hey, they're misidentified as mental health issues rather than pseudo law. And he said court-ordered psychiatric examinations and detentions may result. I implore you to read this R versus Hardy, 2023, April. And, they put us in as a, what are some of the criteria? And that's what I was looking at. Oh, they even bring in, which, they say that for decades, science communication has relied on information deficit model when responding to misinformation, focusing on people's misunderstanding of or lack of access to facts. Thus, and thorough and accessible explanation of facts should overcome the impact of misinformation. However, the information deficit model ignores the cognitive, social, and affective drivers of attitude formation and truth judgments. For example, some individuals deny the existence of climate change. There you go. There's the agenda. There's the narrative. Climate change, or reject vaccinations. Whoops, I just said the word. Hopefully I'm not flagged on this. Despite being aware of a scientific consensus to the contrary. Now, it's really important, those words, how much depth in those words. What they're saying is we can't hear the truth. Remember, you can't patent nature. The system doesn't patent nature. Therefore, everything that they've discussed in the world, through the regulations of government, having rights over the education and so forth, is nothing to do with nature. Nothing. They are speaking to rights of use over nature, to which they create patents over those rights, and then they create ideas like climate change and viruses and so forth. They don't exist in nature. The climate change is just changing because it does exist in nature. They're creating the instruments because they're not dealing with nature. They're dealing with patents, and it's the patents that become agreeable, and then now those become the science that we are now relegated to. Okay? In case you didn't know from my other videos as well. But here we go. And they bring in Magna Carta, lawful rebellion rules. And it goes on, and I'm beating the hell out of this thing. I said, okay, how does that apply to me? Where is it applicable? Again, law. When did I say anything? And then they go into the discussions. And the principle, he talks about the sovereign freedom movement, and they're anti-government, they're anti-tax, they're anti-science, they are, they're above the law, they don't think that they're above society. Society can tell them what to do. That's the premise, okay? And it goes on, and it's just a conversation. So it created the narrative in order to support the judgment. Now here is what created the gulf in my throat. So I go through all this, I'm going, yeah, this is easy. This is no problem, because there's no way I'm an OPCA. Okay? This whole thing is based on OPCA. And it said right here, I'll read the last few to give you some depth before we reach this at the final sentence. As I stated in court on September 2nd, 2022, the court was and is prepared to hear Hardy's legitimate arguments and applications. He has rights under the law and the Constitution. What if he renew the depth of what he just said there? The law and the Constitution. Well, there is law before the Constitution, and there is rule of law under the Constitution. So you should have put or in there, but anyways, we know better. That the court is committed to protecting, including, that's a very key word you're going to find out, including that are committed to protecting, including the presumption of ignorance in the substantive trial. See, law, if you go to the common law maxims, there is no excuse for violation of the law. There's no excuse for ignorance of the law. Okay? There's no excuse to violate the law through ignorance. And that's why you're not in law. For that very word, it says, including the presumption of innocence in this substantive trial. So, substantive, what does that mean? There's another key. This entire order has nothing to do with the matters of legislative authority. It's a court authority. And legal principles are those principles that are held steadfast within the court for them to create security when you enter, that everyone's treated fairly and equally, dependent on the ability to exchange the information back and forth. Okay? And be able to speak freely and not be impeded. But it's including the presumption of innocence. So that's what equity does. It doesn't hold you to the candle of ignorance of the law. Okay? He truly is the author of his own misfortune. Now we go into the sentence imposed. Hardy is of the view that this court had no jurisdiction over him. He is wrong. He has been found guilty of criminal contempt of court. Criminal contempt, see? And I overlooked that when that word OPCA, that's what my mind went to. OPCA. And I went full force into this dismantling this whole thing to prove that I'm not an OPCA. And you're going to see how, I'm just trying to get out of the sun a little bit, how we're our own worst enemy, and always to make sure that you take 100% responsibility. Even when you read it and you think you got it all figured out, just be willing to release it so you can now maybe look at things through a different set of eyes. Okay? And he goes on to say, as I repeatedly said, the present case's primary sentencing goals are denunciation and deterrence. The sentence that is called for must get the attention of Hardy and other like-minded OPCA-type adherents. It must get people to sit up and take notice. It is the interest of justice to do so. You know what justice generally does? Justice is. It protects the rights of the society. Okay? So it's just saying, it's the public interest. That's what we're here for the public interest. And this guy is going on and speaking that he's above the law and the court has no jurisdiction over him, and, so now he's essentially, and I'll put the word as mildly as I can, essentially a societal terrorist, a destroyer of that society and its justice. Okay? It's very important to think about that for a moment. Now, he says, as set out recently by Justice Thompson in Teal Cedar Products Limited versus Rainforest Flying Squad, 2023, In Canadian criminal law, the concept of the interest of justice has come to be understood as encompassing the interest of the accused, the interest of the Crown, broad-based societal concerns, and the integrity of the criminal process. It goes on to say, describe the phrase in interests of justice as a legal chameleon that takes its meaning from its surroundings. The phrase signals the existence of a judicial discretion to be exercised on a case-by-case basis. 166 goes on, in the circumstances, the court must bring home to Hardy and other like-minded individuals the futility of denying the legitimacy and authority of Canada's courts, and the consequence of disrupting and impeding the administration of justice. No fine, a conditional sentence order, or probationary term would be appropriate. Given Hardy's refusal to accept a court's jurisdictions or follow its orders, although I am not ordering cost against Hardy, as set out in Fern versus Canadian Customs, the prospect that in the future costs will be considered against OPCA-type offenders in criminal contempt of court cases should not be dismissed. And here's the sentence. The sentence imposed is 1 year in jail. Now, there's the gulp. My mind goes, reconciles. Yeah, but I'm not OPCA litigant. I don't fit any of the criteria. There is no test to prove that what makes an OPCA litigant. So how can I then have a means in which to justify and measure myself against to see whether I am an OPCA litigant? I'm speaking law. So whether you are ignorant of law, there's a point there. If you now just thinking about it, they don't have ignorance of law is no concern of theirs. The innocence of the subject that's what they then use as an underpinning value to now execute their determinations according to societal and societal laws that justice now has to protect. So, their ignorance is not a player here. But at the same time, I'm using law, so I'm not an OPCA. So I have a day or so to percolate. Like I said, what I do is I let everything go. Am I right? Because I said I don't want to be confined to a belief, because that confinement now can get me into trouble. And it has always, in every case in my life, has done that. And it's the same thing with everyone else. And so just one moment here. So as I was percolating that, of course, again, dropping all my preconceived ideas and so forth, and now I was going to hone in on sending an application. See, that's now reverting back to what the lawyer had spoke to me. He said, well, you can make application in the meantime and discuss this through this case file. And I said, oh yeah, ding, 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 yeah, I could do that. This is a private, that's good, yeah. And not realizing the full potentiality of that comment. But I said, yeah, now I'm gonna now get the judge to give to me the case law, the tests that are necessary in order to arrive at the decision I'm even OPCA, because I don't want, for one moment, if I am now caught within the trial and I'm in trial, give the opportunity to allow the judge to consider, and somehow I believe it won't be the same judge if it does go to trial. I don't think now it's going to, but that have that inkling thought that immediately, he's an OPCA. Because you got to remember, as soon as that comes into the mind of that judge, he now shuts everything down. He doesn't need to do anything else. He just can sit there, let you talk, let trial go on, let things go on. You're an OPCA. And what he can do, though, is stop the court. Now, here is, and I mentioned it in this and reading, but this is what I missed the very, very beginning. It's before I saw the word OPCA, there's one sentence before that, okay? But remember, my mind is geared to bring out something that is going to it's used to seeing, and when you're dealing with these kind of cases, and you're dealing with people like they think like me, who's a freeman sovereign, which is not the case. I don't deal with freemen or sovereign women, just in law. Is the word OPCA, of course. So when I came out, when I saw that, that's my intention went. And then I went, but the very first sentence, sorry to go on there for a little bit, on September 1st, 2022, day one of a scheduled 1.5-day trial, I found 46-year-old Cameron Hardy guilty in facie, a contempt of court, otherwise known as contempt in the face of the court. Reasons for sentence is right at the very beginning of that first sentence. Before it even started, it said reasons for sentence is contempt of court. There it is. The first thing I overlooked is contempt of court. That's how now the judges got the power. They aren't even dealing with the matter that the court is trying to hear, which is why it was brought in. The matter it was brought into court the first time. They are just going, okay, contempt of court. Now that guy's going to sit his ass in jail, and then when he comes out, guess what? This matter's still out. I'm sure he's still going to deal with it. They're going right to contempt of court. Now, there's two contempts. There's civil or criminal. Civil is just while you're in court and you are impeding the other party. Okay, you're doing something the court's asking, you're not adhering to it, and so the other party is affected in it. Criminal, to which this individual was charged with, criminal contempt is affecting the public. Now you're affecting it's of the interest of the public, So the first priority of the justice system is protect the public. So now you're going to get a more severe sentence, which is criminal contempt. And by having that vehicle, which was always there, to now be able to, in like a lockstep, you hit this point, we gave you warning to stop talking the way that you're talking, and it says that so much in this court court sentencing document, and it says that I give him ample time. I told him. Did the judge tell me? Did they warn me of OPCA by handing me this document? You bet your whatever. I had a couple of ideas there I'm going to say, but you bet your bottom dollar, anyways, that he did. So if I went into court and I ignored everything, and I went back into my old belief system, I had a potentiality for a situation that was only using anywhere between $100 fine to a $500 fine. That's it. To end my ass back in jail for a year. Okay. Obviously, is it worth it? So now I had to exercise. Okay. So my first knee jerk is, after reading that, well, I got to defend the OPCA thing first. So I'm going to write an application to get like through requisition kind of thing, to get a judge's opinion based on the matter that I'm bringing to court. Would I be an OPCA? Okay. Well, guess what? Came to me just yesterday morning that yes, I am. It doesn't matter that I could speak to the law any different than someone goes off and says, I'm a living, breathing man, and I have natural rights and so forth, because the matter of the fact is that they already know all of this. But that is not the issue that is brought before the court. They can't hear the issue. They're restrained and confined. So my idea of getting into court is right to a point that I should never have been standing in front of a judge in the first place. The manner in which to go to court is through the private and through application and speak in the private. Do not stand before the court. For that moment, which I experienced by having those documents, I said, what? No, they're in a folder. That could happen at day one. And I know some other people have done that, and they've said, show the injured party, do all that kind of stuff, so it's done in the private. Therefore, it's not discussed in the public realm. They have a legal obligation, 100% obligation to protect society. Society has nothing to do with this, nothing to do with the law. So why would I bring in matters of the law when it doesn't pertain to anything that is in any direct relationship with the public? Because the public is all corporate entities, okay? So what I'm going in there, essentially, with law, I'm coming in there trying to destroy the entire system. Just think about it. I'm walking in and stating, listen, I'm changing the whole jurisdiction of this court, this whole matter here, and I'm going to tell you I prevail because the law prevails and you don't have any rights to the law. Well, there it is. You see something that, again, the devil's in the details. They have no rights to the law. Leave it there. Just think about that. They have no rights to law. You are the only one that has the rights to law. So why would you bring, why would you like bringing a 5-course meal including lobster, a caviar, the highest Russian quality, the finest cut steak, Kobe beef or whatever, and you bring this in, and then you go in and you drop it in front of a 3-year-old. Doesn't mean anything to the 3-year-old. It's just food. Okay, I don't know if that's a great way of saying it, but what we're doing is we're bringing in something that it has no rights to be heard. And automatically, even if you're 100% right, that is not what is being heard in that court. What is being heard in that court is you're not talking to the matter that you're supposed to be talking to. We can't hear you and you can't hear us. So because you're not speaking, you came into the court and you're dealing with this matter, you're not acting responsibly. You're shrugging that responsibility that the public is dependent upon in order to keep order. You are dismantling the legal principles of the court that has to be the hub of any society, of any man. The hub of the court has to be the predominant stronghold so that anyone, whether you're a landlord or a tenant or a man or a woman or whatever the matter should be, whatever capacity, whatever status, that is a place you can get remedy and relief. If that doesn't hold, it doesn't have a foundation and it has a weak link, well then forever on that weak link will then be used against everyone else. And nobody will get justice. We'll have anarchy, and we don't want anarchy. Anarchy it's again misconstrued. We don't want government intervention. We don't want the courts telling us what to do. No one's telling us what to do. We are telling ourselves what we are going to be treated like based on our beliefs. And you can't think your way out of the thinking box. You can't reconcile through a belief. You have to be able to let go of all of these things and realize that everything has its purpose. The police officer has the purpose. If I got some guy coming in my yard and he's shooting up the place, or shooting much of the wildlife that walks through here, or starts taking part in my patio so he can use it for put in his fire, whatever, okay, or steals my vehicle, rapes my sandwich maker, I want justice. And if I don't believe in the court system, and I don't believe in the police officers, where am I going to go? Well, now I'm going to put matters in my own hands and pull out the 12 gauge and do some justice. Well, guess what? Now I'm back in court for the exact same court that I said didn't have a jurisdiction in the first place. Okay, the circle jerk. We have to be 100% responsible. So the fact is, I'm getting to this point of this whole entire thing, is that we And if you're going to court now, arguing council tax, you're arguing foreclosure, you're arguing, the government's right to impede or impede on your property, impede with your rights upon your idea of what you think property is, think it's yours. Well, it's not, as we've learned. Or for anyone to do anything that you don't think that they should have that right. It's like going into a restaurant that doesn't serve, it's not a buffet style, and then going around in each individual's dinner plate and picking out what you want, and only those things, and disregard the responsibility of what you're doing. Okay? The premise is a restaurant, and everyone's sitting down. It's not a buffet, but you're going in there and saying, "Well, I have my right. I don't want to order anything off the menu. I'm just going to pick up things that I want and go off to everyone else's plate and pick up what you want in society." We can't do that, and that's what we're doing. And I was an OPCA then. I was an OPCA. You will be an OPCA. But I did give you the antidote. Inasmuch as if you want to speak to any matters that you think you have a right to speak about, then as soon as you get any sort of appearance or citation or ticket or anything, those are your opportunity to express who you are and how you want to be treated. I will include the caveat: you should know what law is before you do anything, because you might go off on a tangent that, again, is you're going to want the judge's attention in the private, and the judge's going to go, "Yeah, well, you're not telling me anything." So you always have the right in the interim to go in and put whatever is affidavit, whatever you want to put into the court file for the judge to see in the private. So when you now here's your get out of jail. When you go into court, if it's not seen, you just go right to it and you say, don't get into the name game and all that kind of stuff to say, "Yeah, I'm here for that matter. Yeah, I'm David Higgs, whatever." But again, in your mind, you know who you are because you already wrote it in the app that says precedence, right? That it's assumed what you are, but you went in and already set the record straight by what you filed in the private through an application into that court filing. That's not for the public eyes, okay? And you just have to say to that, "Your Honor, I can't speak to this matter for potential contempt of criminal contempt of court. I've already put my reasonings. I've already solved this issue in the private through a court filing that's attached to this case." Do you see what he has to do? If he hasn't got that in front of him, he'll go stand down. He will. He'll stand down. And he's got to go and locate that file. And then he's got to read it. And then I'm going to tell you what you do right after that, which I could have done when he came back from the stand down that I experienced. Again, giving you, something I learned. When the judge comes back, you just go, "So what's your determination?" So I'm just seeking determination based on the file folders that I have presented in the file. That's it. You don't move. See how easy it's going to be? Don't move. He's going to make a ruling on that. You need a determination. You can't move because contempt of court. You just got you free out of. It's not a. The funny thing is like, "Oh my God, I can be called contempt of court. Oh no, man, I'm going to be an old man before I get out of jail. Oh God." They just gave you the out through legal principles. They just gave it to you. You can't speak to it. So therefore, you must only speak to that thing that you put into private. And then the judge comes out in the public. And after he's seen the file, he's either going to say, "Yeah, okay, case, based on the file that I've seen, the Crown doesn't need to see it. I hereby dismiss the case," whatever. Or he'll go on and start speaking about, on a mannerism that he didn't didn't even care about the file. You have got to now assert your rights. You've got to say, which I should have said, Your Honor, based on the marking of that instrument as defective, can we please have, I need a determination on that. That's all I had to stick with. And I'm assured in my own sensibility, again, that's reconciling through my belief, but what I wrote on there, what I did, he would have said, based on that, I have to make a determination because I'm forced to. He's asked for determination. He would then said the Crown dismissed the case. If he didn't, so now let's move on to the potentiality if he goes on or she goes on and it says ignores what's in the folder. Don't fight it. Don't fight it. Contempt is right there. You're fighting. You've already put in the private. You can't now bring it out to the public and start discussing it. You just need the determination based on what was in the. You deposited into the court record. Okay, that's a private issue, and it doesn't belong in public in the public eye. Okay. Man, is this going to be so much easier for a lot of you guys now? And you're just going to, if he doesn't accept what you put in that folder, it doesn't warrant for him to dismiss, then he's going to make he's going to make that ruling based on now that he's going to be subject to an error. That if you were right and he made a ruling and wrong, well, that's okay. Then you got an error, and then you're going to create a case file or appeal for an error. Okay, you're going to ask the application, but also you've got to be ready that you might still be wrong. What you put in there wasn't strong enough. You didn't have a proper legal argument for him to even consider. Let him do that. Don't get offended by it. Don't get upset about it. Just if he doesn't make a dismissal of that case and so forth based on the record and the information that he's received and just looked at. All right. Thank you. Make sure you've got, they give you ample opportunity. They give me, 3 periods before I go into the trial? 3 times. So that's 3 months to get my shit together. If your very first appearance, you got the same amount of time. If you are in the crux of it now and you don't know how to do this, if you know the law as much as you need to know and how to express yourself, then I would file an application in private. I put maybe across it written special priority private, just so that, for the judge's eyes only, that kind of thing. Just for the court registry not to read it, just to plop it into a folder for you. And then have that folder. You don't even need to file it in the record for the Crown to see or whoever the prosecution or plaintiff may be. You can just file it for the court, for the judge. Okay, put it in the folder. So this is for the judge. Okay. Then if you're the next day or in that situation and you're feeling you're in the crux of dealing with the trial, stop right there and going, Your Honor, especially if you're talking pseudo-legal arguments, I want to refrain from discussing this matter anymore for the prospect of criminal contempt. As such, I've got a folder I put in the private, and I need that to be considered before you move on. You can't move. The trial stops right there. He might stand down and he might come back and says, you got to adjourn the case. He might stand down, come back and go on with it. And you're going to realize, well, I didn't say, you're going to ask for determination. Well, what I wrote in there, does that not warrant this case to be dismissed? If he says no, then you haven't done it correctly. Then you say, okay, don't shut up. Okay, that means you got to fix it. Take responsibility. Fix it. Or he comes back and, have to stand down and starts asking more questions. But those questions can't be relative to the private matter. So you got to watch that. If he starts asking you questions about what was in a folder, then you shut the hell up too, because that's going to be contempt. I don't even think he would do it, or she would do it. The judge wouldn't do it, because then they would be contempt of their own jurisdictional authority. So there it is. It's a long video, but it's been months since I put one out, so you can cut it up in 10-minute segments if you feel better. And then you got 70 or 80 segments or 90 segments, whatever, 90 segments, um, and digest it that way. But when I began this video, the introduction, this is like one of the most important videos I will do. It is, for that matter. It's saving us. It's doing. We're retaining the peace. We're not being a combatant. We're not engaging in a debate. We're not engaging in legal arguments that we have no rights to even deal with. They give us an out of criminal contempt for discussing anything of our private right, which proves right there we can never discuss those matters. And it's given us everything. That little shock therapy that I received has given me everything that I need to know. I can't go into court because of criminal contempt, unless I'm willing to discuss the matter, which I'm not, because on the reasons that I would overreach would be my powers not to be engaged in their system of commerce, because I have to have they have notice of agreement. So with that, God bless. Like, subscribe. Thank you for all those people that have donated. There are some that donate regularly, because we've engaged in some conversations, some of them, but some of them have valued the information so much. It's totally changed your life, because your power is knowing the law. Your power is not forcing yourself. That's not power, because we experience that in society. Everything's forced. And it's forced by fear. If you do this, or this could happen. It's like, when you were kids, same thing, same rhetoric. If you don't eat your Brussels sprouts, you're not getting your ice cream. Okay? Or you're going to bed without any dinner. It's the same model since kindergarten, or even before that. So that's how the system runs. Do this or else. Do this or else. Remember, the system, which I like to segregate, the Imperial Acts, back up just a little bit. Law is commanding what is right and prohibiting what is wrong, and that's in Blackstone's commentaries. Commanding what is right, prohibiting what is wrong. To me, Imperial Acts command what is right. Codes, by their definitions, I think command what is right. I haven't read them all, but looks of that nature. As for statutes and legislation, those things that are government, they prohibit what is wrong. And what is going on is the Crown is, first of all, babysits, especially looking at the Commonwealth. It babysits the infancy of the government, who has the right to the use of the estates that are represented by the Crown. How do we know that? Because in the Bill of Rights Act, as we learned, 1688, right there shows it's a preemption to the Act, giving us the introduction of what the Act's about. It says, hereafter enacted by His Most Excellent Majesty, through the advice and consent of the Lord Spiritual, Temporal, and of those commons, lawfully, fully, and freely representing all the estates, say it one more time, the estates of the people. So they're representatives, they have a duty and they have an obligation to the people, who then give a lesser right or subordinate right to governments to then the use of those estates, to which, until that government, like an infant tenancy, between landlord doesn't know the well-being of the tenant and what if they're gonna adhere to the tenancy rules, or does the tenant know that his landlord is going to do what he said he was going to do, and take care of issues that might happen on the premises if things break down and stuff like that. So we're at the very infancy. So when you first grant that right to government, the training wheels are on, and thereby everything that the government then thereafter creates for a term has got to be filtered through the parliament, because the parliament's representing the estates of the people, and the government has been given a patent right to then proprietary right to then use that land, and they have to be regulated so they won't be stored and go all crazy and then just leave a big hole and then leave, that kind of thing, right? So they have to make sure, first of all, that they are self-imposing rules of commerce upon themselves while they're in the use of the land. And then when they become self-sufficient, they wrote enough statutes, they've had enough court cases to show that they were responsible. Then the training wheels come off, okay? But they're still closely observed. The crossing guard has sort of removed himself from the need to stop traffic in both ways so you can cross, but essentially the crosswalk is still there and you're still going to cross it, so you're still under watchful eye that you're looking both ways, that the government is still regulated through the laws and conditions that were set forth at the very beginning for the government to have the right to use those estates of the people. And while that's going on, up until, and this happened in 1982 in Canada, where the Constitution now was the legislative authority could now amend the Constitution, could now fix it based on the matter that they are fully independent, inasmuch as that they have written enough rules that if the Crown finds that they're breaking, that there's enough rules for the Crown to come in and say, oh, you broke this one, and then charge them. Oh, you broke this one, you charge them. So when I'm driving on the streets with no license, the government says, yeah, we're going to have all of our citizens have licenses before they can travel on the road. The Crown goes, oh, well, here's somebody who's not with a license, so that means that's a break of that rule that you created to monitor your citizens, to control your citizens. So we're going to go into court and use the sections that you've created for us to use as security upon the information that then becomes a deposit for the court to hold that and then wait until whether or not that the proof has been validated that in fact the law was broken, or that it wasn't. So either the instrument is charged or not charged. And once it's charged, then of course the Crown receives the values of that instrument. And how that works, we don't know. Again, that's not our business. It's between the government and the Crown. They have a contract. You don't have a contract between the both of them, either one of them. Just like you don't have a contract with the Federal Reserve Bank. That's between the government and the banks. And nor do you have a contract directly between the Reserve and the member banks. That's between them. You only have an agreement subject to your own actions. And with that, have yourself a great day.